Hail and well met slayers of giants. So if you've been following the bricks and minifigs situation, what I'm about to share with you is going to explode potentially around the internet. So buckle up, because this is a big new piece of evidence. I will leave that to you to decide. So just to back up, for those of you who are new to all of this and you're going, wait, what the heck is this guy talking about? My wife, Chris, and I, we owned a franchise store in Salem of a bricks and minifigs store. So that is a store that sells Lego, both new sets and used sets. It was going very well. We were building up a really good relationship with our community. I should say I was the kind of silent partner. I'm a teacher, so I had a full-time gig, and my wife Chris was the manager, and she was doing very well. They were impressed with her. They were so impressed with her that they would at one point called her in to be their evaluator of another collection, because they knew they respected her expertise, and they were talking about her, not just in the Slack, but at conferences about how they were excited about the work she was doing. The store's sales were increasing, things were going well, and so the person who was her point of contact with Bricks and Minifigs, who's no longer there, said, "Hey, you might want to consider purchasing the franchise." And we talked about it, and we said to ourselves, okay, this is a company that is owned by, a couple of guys who are into Legos, and they're Mormons from Utah. People who are into Lego, in my experience, tend to be nice and honest. And just about every Mormon I've ever known, nice and honest, right? So we thought, okay, this is going to be a good idea. And we looked, we did our due diligence. We looked at their prospectus, which they provide to folks, and that's a legal document. Like they cannot lie in this document. And they showed this is what we expect as far as the return on one of these franchises. If it's well run, and of course ours was being well run, Chris was doing a very good job, this, will increase in value at this rate, and in 5 years, this is what you can expect, that kind of thing. So we thought, okay, this is a good investment. And there were some red flags right away, which we should have recognized, but this is what you're going to want to pay attention to. So early on, there were some violations of the franchise agreement right away on BAM's side. And Chris can speak to all of this better than I can, because she was the one in charge of the day-to-day operations, but they didn't turn over the connection to the bank account properly. They didn't turn over the connection to the lease that was supposed to be done according to the franchise agreement. They didn't turn over access to the social media accounts. So you have to put yourself in our shoes a little bit. We just purchased this store. We were excited about it. And these nice people were saying, no big deal, don't worry about it. Put a pin in that. That's going to be important later. So they're saying, no big deal. We'll just take this amount that you tried to pay the bank, or that you tried to pay for the rent for the store, and we'll cover it, and we'll tack that on to what your payments that you're making for purchasing the franchise, right? Okay, no big deal. Everything's going fine. Then one day, Brian Mansell comes in. You know about Brian Mansell. And he comes in and he makes this consignment agreement with Chris. Everything's going great. He's getting his payments. Those sets are being sold. Everything's fine. Then, one night, on just a random night, a guy comes into the store and says, essentially, give us the keys. We're taking this store back. And then, in violation of their own contract, refuses to provide us with an inventory. They're supposed to say, hey, these are all the things we are alleging we just get to have, right? We're claiming we get to have. And if we look at that, according to the franchise agreement, if we look at that list and say, this is not accurate, these are not what these things are worth, Note, we can't even say what those things are if they're not in there, right? But if they had given us that list, we could say, nope, these aren't what they're worth, and we're allowed to say these should go to a third-party evaluator. And that person would then go through and say, yeah, no, that's not what that's actually worth. Those cases, for example, that hold those minifigs, those glass cases are very expensive, right? It's not just the Lego. The Lego are valuable. The furniture's valuable. The cameras are valuable. All that's, the shelving, all that stuff. We were not only not compensated for any of that, none of that stuff was listed. Remember that. Now, this gets a bunch of attention because when they take the store, they take the Mansell collection that's inside, right? And so that's why the internet is going, this is clearly egregious. This is just, unconscionable. They have taken this thing that doesn't belong to them, and it's very straightforward, right? But what if taking stores away is a pattern of behavior? I'm not saying that it is. That will be for the courts to decide, right? But I have some potentially explosive evidence that I want you to consider. So this was just shared with me by somebody who is excited about this case and has been doing this research and found the complaint made by another location about what happened to them, and I will let you decide what you think when you hear about their experience. So here is the complaint. This is publicly available information, right? Circuit Court of the State of Oregon for the County of Clackamas, Plastic Pallet LLC. This is a different store entirely. This is the store in Clackamas County in Camby. So they entered into their franchise agreement in 2017. Everything's going fine, right? BAM violated the agreement in numerous ways. It also committed elder abuse, interference with contract, and intentional infliction of emotional suffering. Among other things, it offered to assist Plastic Pallet and Ms. Cooper to find a new franchise to purchase her interest and take over the operations of the store, then reneged on its offer. It falsely accused Plastic Pallet of breaches of the agreement and threatened to abruptly terminate the agreement without adequate notice. Without adequate notice. You decide. Pattern? It unreasonably withheld its consent to transfer of the membership interest in Plastic Pallet. It refused to assist Plastic Pallet to find a buyer without good cause. It threatened to, and did, terminate the agreement and destroy any equity in the business. It interfered with the business plan adopted by Plastic Pallet by encouraging its members and employees to violate their duty of loyalty to the LLC. Okay, here's something else that's important. At all material times, Plastic Pallet operated its store in compliance with all of the material requirements of the agreement, or any alleged non-compliance was waived by BAM. Sound familiar? No big deal. That one's on us. We'll take care of that. During and around the summer of 2022, BAM began interfering with the internal management of Plastic Pallet. Among other things, BAM attempted to force certain members to give up membership and control rights of the LLC. Additionally, BAM inserted itself into conversations with Plastic Pallet's landlord in an aim toward causing the termination of Plastic Pallet's lease. Defendant BAM attempted to impose new management and to control the operation of the LLC, including the threat to destroy a member's investment if they did not comply. Just saying. Defendant BAM was not an actual party to the contractual, professional, and business relationship between Plastic Pallet's members, nor as between Plastic Pallet and its landlord. Keep going here. On or about October 30th, 2023, BAM took possession of all the assets of Plastic Pallet. Despite repeated demands, BAM has failed and refused to provide an inventory or valuation of those assets, has refused to disclose the location of the inventory and continued using other assets, and has refused to purchase or otherwise liquidate those assets. BAM has wrongfully withheld and intentionally exercised dominion and control over Plastic Pallet's assets in a manner which so seriously interfered with plaintiff's right to control it that defendant should justly be required to pay plaintiff for the full value of the assets. Notice this next word. As a result of BAM's conversion of the assets, this is a word that was new to me, right? This is what lawyers talk about when they talk about saying, I get this thing, your store, and I just get the stuff. If you don't actually have the right to the stuff, lawyers don't say you've stolen it. They don't say theft, right? These are different terms legally. They say you've converted it. So this lawyer who's written up this document has used that term. As a result of BAM's conversion of the assets, Plastic Pallet has been damaged in an amount equal to the market value of the assets at the time and place of its conversion, in an amount to be proven at trial estimated to be $200,000. Sound familiar? Plastic Pallet is entitled to interest at the legal rate, da-da-da-da. Okay, now, again, I leave this to you to decide if this is a pattern. Plaintiff Cooper is over the age of 65, in poor health, and is extremely vulnerable both physically and emotionally. Plaintiff Cooper is a vulnerable person, as that term is defined in ORS 124.100. BAM and other defendants are and were aware of those facts at all material times. BAM attempted to force Plaintiff Cooper to give up her control and to turn over her membership in the Plastic Pallet for no consideration. Another little detail. The night that our store was taken from us, we get on the horn with the person who is the contact person, whose title, I believe, was executive director, according to their LinkedIn profile. BAM has since tried to diminish the person's role in the company. I feel kind of badly for them to be thrown under the bus in that way, like they were a meaningless underling. Well, they were the person that BAM entrusted to manage this situation, and while we were on the phone with this person, they threatened us. You heard the phone call. The guy said, if you try and sue us, if you go that legal route, your lives are going to be shit. Right? We're going to drag this out.
What I'm going to tell you right now is if we go the legal route, there is no option for clean slate. We will be seeking all the liquidated damages. And that is going to be an expensive battle. You're right. It's going to be a very expensive battle for you. There's not a whole lot of options for you. If you want to go the legal route, it's just going to be a mess and it's going to be expensive for you. If you fight this, then you're putting yourself into a whole lot of shit.
They said exactly what they would do. And they said, okay, we've figured out this number, this magical made-up number that is a composition of your remainder that you were paying us for the store and all these fines that we've tacked on.
And there's been some late fees tacked on that.
Remember, the remainder was already increased by the fact that they failed to turn over the bank and lease information.
The lease is technically in our name still, which I don't know the whole situation that went into that either way.
But now they're using that against us, and they're saying, here's this big number of amount you owe us, but we're just going to let that all go. You don't have to pay us that amount of money. We're just taking the whole store.
What we decided, what we figured would be better, and what you guys would appreciate is if we just both walked away from this clean slate. Like,
yeah, that's not clean slate.
So I would sit down, you and Crystal, talk over the $100,000 and figure out if that's going to be worth it to try and fight that, you guys, because I'm going to tell you right now it's not.
I want you to consider, and please take this to your employers, how is saying you have no options and if you don't do what we say you're going to be in a whole lot of shit giving grace? Does that sound like grace to you?
What's giving you grace is saying that we are not going to go after you for that $100,000.
Does that sound like grace to you?
It sounds like a threat, and I can acknowledge you feeling that because in a way it is.
It sure would be bad if something bad happened to your store, right?
Okay, I'm glad that we've established that you ended this relationship by threatening people and then them taking a financial loss. Because when we need to go to people who are saying, should we start a business with bricks and minifigs, we can say, in all honesty, they ended the relationship with us by threatening us and then demanding that we take a loss. Consider that when going with them for a franchise. They leave you holding the bag and they threaten you as you go out. And you just acknowledge that. This is the way you do business.
I really, really encourage you to read through that termination agreement, because there's going to be things in there that if you seek to go after us, or if you seek to defame us, like that's also not a pretty. We're trying to do our.
I would not say anything untrue.
Right? So that was my experience. That's all I can speak to, right? I can only tell you my personal experience with BAM. I'm not going to speak out of turn, but remember that also. Defendants attempted to force plaintiff Cooper to give up her control and to turn over her membership in the plastic pallet for no consideration. On information and belief, BAM conspired with and communicated improperly with third parties, John Does 1, 2, and 3, in an attempt to undermine and force Plaintiff Cooper out of the company. Although defendants knew that Plaintiff Cooper had invested her life savings of over $120,000 in buying and financing Plastic Pallet, they threatened to wipe out her entire investment if she did not comply with their unreasonable and improper demands of BAM. Sound familiar? So there's this clause in the franchise agreement that compels binding arbitration. So you go to mediation, and if that doesn't work, you then go into binding arbitration. In Utah, with an arbitrator that you and the other side have agreed upon, but it's not somebody from Oregon, it's not somebody from your own home turf, it's somebody in BAM's turf, right? And understandably, Ms. Cooper's team did not want to go into binding arbitration. So the hearing that you're going to hear some clips from here is not really about the case itself. It's Ms. Cooper's attorney arguing they shouldn't have to go into binding arbitration and allow BAM to, behind closed doors, try and deal with this situation. He's arguing she should be able to go in front of a jury and make her case, especially when it comes to the situation that is elder abuse. So check this out.
What they characterize as a routine commercial dispute is really anything but. The behavior of this franchisor goes so far beyond any of the, and I think the key word in their own arbitration language is obligations. They talk about provisions, specifications, standards, or operating procedure, or any other obligation. So clearly what BAM was doing in drafting this agreement was saying that there are specific matters relating to this contract, which if we violate our obligations under this contract, then arbitration controls. But when you look at things like, and it's alleged very clearly, and I think Mr. Cunningham would agree, direct interference with employees of Plastic Pallet to try to encourage them to violate their duty of loyalty, a conspiracy to try to, in effect, destroy the equity of Ms. Cooper. The fact, and I really have trouble with the distinction that I think Mr. Cunningham's trying to draw about conversion as an example. Admittedly, the property we're talking about belonged to Plastic Pallet, but the allegation and the facts are they took everything. They took every asset of Plastic Pallet. They did so without consent or permission, and they've now said, somewhere in their reply, they said that it was abandoned or that they've been offering to give it back.
Sound familiar?
And let's look at conversion for a minute, Your Honor. There is a provision in the contract that allows BAM a right of first refusal to purchase assets belonging to the franchisee. Now, if the problem here was that they exercised their right of first refusal and we wouldn't sell them the assets, or that they did exercise their right and they took the assets but we disagreed over price, all of those things, I would think, well, those are obligations. Again, that's the key word. Obligations of theirs under these provisions, specifications, standards, and operating procedure. But what happened and what we've alleged is, I don't know if we said under cover of darkness, but that was basically the way it happened. They took everything, and they've now apparently stored it somewhere. They've never told the plaintiffs where the property is. They never offered to give it back. And so to say that that violates an obligation simply because there are provisions for them to buy the inventory, to buy the assets, but that's not what they did. And that's not an obligation that they violated. They just took everything.
And I don't want to go overboard and say that BAM's attorney did anything improper by not contesting these allegations, because that wasn't the question at hand, right? The question at hand was whether or not it could go to binding arbitration. And so their attorney doesn't say, no, we didn't take all the stuff. He just says taking all the stuff relates to the franchise, and anything relating to the franchise agreement is therefore arbitratable. Arbitratable? Is that the word? Arbitrable? So we shouldn't be having this conversation about whether or not we can avoid arbitration. Now, I don't know what happened. Did they go to arbitration? Did they settle behind closed doors in some other way? Who knows? But here's what I am hoping you are thinking about. Conversion. Elder abuse. Taking the store in, according to the words of Ms. Cooper's attorney, the dead of night. I had one experience, right? I know what happened to the store that I co-owned. But think about what if, right? Hypothetical. What if this is a pattern? I let you decide that. But think about the nature of the way that would work. So you say to folks, hey, you should get a franchise with us. We're really nice guys, right? We're not going to do anything bad. And then, early on, you just make it impossible to make a payment, for example. You violate your own franchise agreement. And you say, sorry, that's on us, no big deal. Anybody who just bought a store, they're excited about their own store, they're worried about their own store, and the franchise is saying, it's not a big deal, we'll take care of it. But they've created a pretext to then later say, hey, you violated the franchise agreement. Who violated the franchise agreement? Right? So you've got a real clear case. I'm not the one who violated the franchise agreement. You violated the franchise agreement. But then they come in years later, you've built up your business. This thing that you purchased was worth this amount. You've built it up so that it's worth this amount. You've loaded the store with inventory, right? And what if what happened to us has happened to many stores? Somebody just shows up and says, we're taking this thing back. You violated the franchise agreement. And if you don't turn it all over to us, oh, and by the way, we're being nice. We're going to wipe out your debt. All we ask for is just the store. Aren't we nice guys? Right? And they take the whole store back, and then they can resell it now at this increased value with all of your inventory inside. Think about the profit margin, right? You made money selling the place in the first place. You took it back, and you can now sell it to somebody else, like, I don't know, Brandon Best and Josh Johnson, who can then take it and make more money on it. That would be a really remarkable business model, wouldn't it? To just be able to sell franchises to people and then take them back when you see fit. I'm not saying it's a pattern, but all these documents are publicly available. I'll include the links to where to find them in the show notes, so folks can go through and see what happened to the store in Camby and make up their own minds about what this means in relation to the way that BAM does business. So what happens next? Chris and I are in this fight to the end. We have a very smart attorney. You've probably seen folks on YouTube letting you know, these legal experts saying, oh, her filings are very good. She's very smart. What they don't say, because to them it's left unsaid, is she ain't free. So please hop over to our GoFundMe, not the Mansell GoFundMe, mind you. They're distinct. and that is for our legal defense. And when you get there, you're going to see a number, and you're going to go, that's a big number, because normal people, you and I, we look at that and we go, that's a lot. Well, guess what? That's not nearly enough, because we know Bricks and MiniFigs' legal strategy. They told us, right?
It's going to be a very expensive battle for you. There's not a whole lot of options for you. If you want to go the legal route, it's just going to be a mess, and it's going to be expensive for you. If you fight this, then you're putting yourself into a whole lot of shit.
They're going to make this difficult. They're going to make this expensive. And it's probably going to take a while. And so what we need is for folks to continue to fight with us and to sustain the pressure. Now, of course, be civil, right? I'm not asking for anybody to do anything that is dangerous or harmful to anyone, but let corporate know we're aware. And all of their efforts to try and defame us, to cast all the blame for everything that's happened onto Chris and onto me, let them know it's not going to fly. Especially if you believe, and again, I leave this to you, especially if you believe, based on the evidence you've seen, that this is a pattern of behavior, which again, I'm not weighing in on, let other people know. Share this video. Subscribe. I'm writing an entire serial novel about what's been going on over the course of the last year. If you've got time, please, by all means, go back. Tried to make that entertaining by, having magical creatures and, knights errant in it. But it is a bit of an allegory, one might say. So if that would be an interesting, fun way to catch up on things, please go there, check that story out, and tell a friend about it, and support us as we go forward with this case. And we're going to find out, brick by brick.